I'm going to read some housekeeping and then we'll get going. So hi, and thank you for joining us for today's webinar on picking the right QME specialist. My name is John Blake and I'm the Director of Sales here at Gemini Legal. Before I introduce our panel, I'd like to make a few housekeeping announcements. This webinar is approved for 1 hour general MCLE credit. To qualify for the credit, please remain here for the duration of the program. At Gemini, we strive to be a resource for the entire legal community here in California. You can find past webinars, interviews, and podcasts on our Gemini Legal YouTube channel. We should have time at the end of the program to answer questions. To ask a question, please do so by clicking the Q&A button at the bottom of your screen. Now that housekeeping's out of the way, we can get on with introductions. I'm super excited to have 3 fantastic panelists with me here today. I'll let each of the panelists introduce themselves, starting with Robert.
My name is Robert Herrera. I am the managing partner here at the law firm Iglo, Bacharach, and Herrera. I have been practicing workers' comp since 2017, first representing defendants and now representing applicants since 2019.
Great. And okay, go ahead, Dr. Coppelson.
Hi, I'm Aaron Coppelson. I'm a physical medicine and rehabilitation specialist. Did the training locally here at UCLA. Been doing QMEs for many years and treating tens of thousands of patients for over 2.5 decades.
Wonderful, thank you. And now Judge Graff, who I believe also has to read a disclaimer.
I do. So I'll introduce myself and then I'll give the disclaimer. Good afternoon, everybody. My name is Judge Adam Graff. I am a judge at our Van Nuys District Office of the Workers' Comp Appeals Board. I've been on the bench for 3 years as of 5 days ago. Prior to that, I was an applicant's attorney with the office of Shelley and Graff in Pasadena, and been a certified specialist since the year 2019. And any of the things that I say, the opinions expressed by me are my opinions and mine alone. They do not constitute the opinions of the state of California, the Division of Workers' Compensation, the Department of Industrial Relations, or the Van Nuys District Office. They are only good as far as you can throw them. Thank you very much.
I like it. And congratulations on your 3-year anniversary.
Thank you.
All right. Before we start, Dr. Coppelson, what exactly is a physical medicine and rehabilitation doctor?
An interesting question. It was a field that was born out of World War II, and it combines the fields of orthopedics, neurology, and internal medicine. They saw that our soldiers that were coming back from war had internal medicine, they had all those issues, but the neurologists didn't know anything about ortho or internal medicine. Internal medicine didn't know anything about neurology or ortho, et cetera, et cetera. So they needed a head of the octopus to kind of order the right consults, manage the right team, and then get the patient better and get them hopefully back into normal life. So our training, I'll give you a quick thumbnail. We do Rancho Los Amigos Hospital, which is brain and spinal cord injury for about a year. You do Cedars-Sinai Hospital, where you're doing inpatient internal medicine. So patients who've had stroke and other issues and hyperkalemia, kidney issues, liver issues. And then you do 2 years of outpatient orthopedic injections, epidurals, nerve tests, and things like that.
Wow. It's a lot of training. It's quite a diverse grouping.
Right.
Pretty neat. Okay. All right, let's hop in. So what are the main issues applicant firms come up with in getting the proper panel, Robert?
For me, it's whether the defendants are going to fight us or not. So a lot of times, I want to proceed with a physical medicine and rehab panel or a pain management panel. But I have my client's best interest to move this case along as quick as possible. And I know that if I do that, sometimes that the defendants are not going to be happy and they're going to put up a fight, whether it's objecting to the panel and going to the DWC medical unit, or whether it's filing a DOR for an MSC and then having to go to trial on this issue. So we kind of have, I know that maybe in court I will win on this issue, but the practicality of it is that I want to move this case as quick as possible. So sometimes I need to determine, what may be the path of least resistance. So that's kind of an issue that I come up with is, I know that maybe the most appropriate specialty is physical medicine and rehab. But I have to also take into consideration whether I should select an orthopedic surgeon so that way I don't have as much blowback from the defendants.
Gotcha. And when you don't agree with the other side, you generally do a meet and confer, right? How do those tend to go?
I would say that you should do a meet and confer. Whether those really happen or not is very, very limited. I would prefer to show up in front of Judge Graff and tell them, like, hey, we discussed this and, we can't agree to, a QME or an AME. But I would say about 10 to 20% of the time that when I request a panel that the defendants don't agree with, they then come back and they will agree to an AME. In my practice, whenever I send out letter of representation to defendants, I always send out a proposed list of AMEs. 9 times out of 10, I never hear back regarding one of those AMEs. But if I request a pain management panel, a lot of times defendants will then come back and say, you know what, we'll select one of those AMEs from your list. And that makes our job easier, right? Now that we have an AME, we know we're going to move this case along. We know that things will be done a lot more efficiently. So I would encourage defendants to meet and confer more.
So even though there's only a 10 to 20% agreement rate during that meet and confer, it does give you other options.
Yeah, absolutely. Absolutely. Yes.
Okay, cool. And if it does go before a judge, what do you consider when making decisions on this?
Well, if the question is whether the specialty is appropriate, unfortunately, there's a lot of game element in the selection of the QME. And as you folks all probably know, the standard for changing the specialty is not, is there another specialty that might be better suited to dealing with this? Is this specialty selected medically inappropriate to deal with the disputes that are before the parties? And that's almost never the case, because most of the time, if you have a musculoskeletal injury, the specialty selected is going to be either orthopedic surgery, pain medicine, PM&R, chiropractic. All of those specialties are going to be capable of dealing with the issues. And the board has said over and over again that it's not a question of, is this one better? It's, can the QME answer the questions within their purview? And usually they can. So it's almost always who wins the race to selecting the QME specialty.
And so I do have a question that's interesting in the questions here. It says, what software or bot are the defense firms in California using to win the race for the online QME panel request? They're tired of losing the race and getting stuck with Fresno orthos. So I thought that was cute.
Oh, I would give just their advice, to any claims adjusters, as soon as they get on the file, I mean, they should refer it out to a defense attorney, because a lot of times I'm getting files, I'm getting the notice of denial, and there's no defense attorney on there. And that's the green light for me to just go ahead and request that panel.
Gotcha. Okay. So I understand that when there's multiple body parts involved, that PM&R specialist is probably a good option instead of the ortho that is often put forth by defense. Why is that, doctor?
Well, I'm obviously biased. What I like about PM&R is that the reason I went into it instead of ortho was we look at more of the gestalt of the patient. You look at the whole patient, because you're not just looking at the neuro, the ortho, or the internal medicine. And that Venn diagram has so much overlap that it's not, if you're a hammer, everything's a nail. You're not, you're more like Home Depot. You pick the tools you need to get the patient's diagnosis, and when you're treating, to get the patient better globally. Just this morning, I just finished dictating a QME that was sent essentially for a low back and what looked like a high radiculopathy, an L3 radiculopathy. But it wasn't that. The patient had an inguinal hernia and had it's called the lateral femoral cutaneous nerve, a whole other nerve, a nerve most people don't know, most people don't pay attention to. So this whole case is going towards the back, and everyone's like, well, the MRI is normal, MRI is normal, EMG is borderline. Well, because you're looking at the whole patient, you see that it was actually an inguinal hernia when he picked up the sign. That's what I think is important in terms of PM&R. If you're a hand guy, you're just going to rate the hand. And you maybe you know the hand chapter better than anyone, but you don't know that, look, there's a chapter 13 out there. And if there's a dominance in the hand is not in the hand chapter, it's in chapter 13. Or there are gait abnormalities in chapter 13 that you're not applying to a guy with a knee surgery. So you're looking at the whole of the patient. Real quick, I'll give one quick example. I have, post-operative patients who have post-anesthesia syndrome. So you're not just looking at the knee, but you're looking at the 3 knee surgeries the patient has, and the cognitive deficit is a compensable consequence of the type of anesthesia that was used. Or the hypertension is a consequence of the 20 years of Motrin that's used for the back pain. Or it's not, or you're really looking at the records real deep and saying, no, they had hypertension before they even started and they're actually doing better at work. But the point is, you look at every joint, every nerve, the whole body, and you get the case resolved better and more completely than disjointed.
So if that's the case, why don't we hear a lot more about this specialty?
Yeah, we're a freckle-faced, red-haired stepchild of medicine, right?
Resembled that remark. Sorry.
So there aren't a lot of us that go into PM&R. It's a relatively small field. It's a very academic field. It's a hospital-based, research-oriented field. So that's why there's a few of us that kind of get out there. And that's why your panels, when you order a PM&R panel, you're going to have 5 or 10 guys versus 80 guys, which is another good reason, I guess, to get a PM&R panel, because it's a more intimate panel. It's almost like getting an AME. But the guys that go into PM&R are more cerebral than rather than driving to 10 clinics and seeing and getting in depots,
So what type of injuries can this specialist rate?
So it depends. For SIBTF, which has become suddenly the bigger part of my practice, I rate everything that I've been trained in. So neurology and Rancho Los Amigos is a globally recognized brain and spinal cord injury. I comfortably rate neurology. I comfortably rate most internal medicine unless there's some crazy kidney defect that's end-stage renal disease, because I've been treating it at Cedars-Sinai. I do inpatient at Cedars-Sinai. And then, of course, orthopedics is 25 years of doing orthopedics. I've probably done probably at least 10,000 injections. So long story short, I rate all of those with SIBTF. If it's a more but on a QME it's a little different. I will look at the blood work. I will look at the medicines they're on and the side effects of the medicine and see if it's just a hypertension and the patient's been on Motrin and it's really the hypertension has started since the patient's had the back pain and the Motrin. I will very easily make it causally related and then give recommendations for that. But I've noticed there has been some pushback, and maybe Judge Graff and Mr. Herrera can say how comfortable they are with guys like me rating the basic stuff, the hypertensions, the rheumatological stuff that's within the framework of my specialty that I comfortably rate, but are they getting pushback on the other end of things?
Yeah, definitely we will get pushback and say, like, hey, Dr. Coppelson is not the right specialist for this, especially if it's coming like something internal and whatnot. But this is an issue that we are always coming about, is getting different specialties, having to go to multiple panels. My opinion is like, hey, why not get it resolved with one PQME?
I welcome it for that reason. And if a doctor is going to tell me that they believe they are competent to rate those areas, then unless I've got some evidence which suggests that they are out of their depth, then I think it's fantastic to have one opinion that can cover all of this and would also reduce the cost of litigation by having one evaluator as opposed to multiple. So I welcome that.
And this kind of goes to the case that you sent over to me, right, Judge? In that, I thought that case was pretty fantastic for what we're talking about right now.
Are you talking about the Salcido case?
Yes, exactly.
Uh, I had looked at that case more in line of when is it justifiable to order an additional panel, but yes, I mean the question is really what evidence do you need? As a judge, I cannot, and the board has made this clear over and over again. I can't say, well, the absence of evidence means that the applicant doesn't get this benefit. It's if I've got nothing, I have to have something. I have to have an affirmative opinion that there is no injury to this body part or this whatever in order to make that finding. If I've got the absence of something, I have to fill the vacuum. And I think that case really does talk about that, which I'm happy to discuss more in detail. But that's you have to have evidence. You can't say the absence of evidence means applicant loses.
So if the applicant is saying that, you know, everything that the defense is saying they're going after the right shoulder, but the applicant's saying, no, I have a problem with my hand. And the doctor says, no, I don't really do hand, they can get a hand doctor on the panel.
Well, I mean, yes, that's exactly what that case says. The case that we're talking about is a case that just came out in February called Ramberto Salcido versus Waste Management Collection. It is 2024 Cal Work Comp PD Lexus 63. And this got featured actually in Lexus's newsletter talking about the 25 most important cases from the first half of the year. Wow. And the head note of this case was talking about how the applicant had claimed injury to internal body parts, and the orthopedic QME didn't render an opinion on that. And there was no evidence from any treating doctor that the applicant had any complaints or treatment history for any of these internal problems. It was simply alleged. But the applicant's attorney asked the ortho QME, are you competent to address these claims? And the ortho QME said, no. And so then the board said, well, that's grounds for an additional panel in internal medicine, because despite that there's no evidence on this, you have to have evidence. And if this doctor says they're not capable of addressing those complaints, then you have to have another panel where the doctor will address those complaints, the allegations. So that's what that stands for. And that's clearly the trend of where the board is going, where you need the right to have discovery and more evidence as opposed to we're just going to cut this off.
Yeah, that's fantastic. And I did share that, and thank you for sending. I did share it as part of the reference materials. I sent a second email with that on it because I thought it was pretty fantastic. So thank you. And so let me kind of go back to the PM&R specialists. And so Robert, why do you think defense tends to object to this type of a specialist?
Because I think they want a PQME whose ability to rate to be limited, right? So if it's a hand injury, you know, they're only going to want somebody who's going to be able to rate the hand, or orthopedic surgeon only going to be able to rate on those levels. Like Dr. Coppelson said, he's like, hey, he's able to rate a lot of other things that are within specialties that orthopedic surgeons can't do. So, you know, they want their PD to be very, very limited.
Now that seems to not make a lot of sense, because if you have a doctor that can rate everything, then it's going to, like the judge said, reduce the cost of litigation. So do you think that'll change over time?
You know what? I don't, because it just seems that the trend of defendants is to limit your ability to seek more QMEs. It's very, very limited that, you know, I have my partner who's appearing at an expedited this afternoon in the Van Nuys board, where the PQME is clearly saying, hey, this psychiatric specialty is appropriate, or psychiatric evaluation should occur, and they won't roll over. They won't, I send them the joint request to sign it, and they just want to litigate because they know that it's going to come at a cost to their client. I know that, coming from doing defense work, maybe you are recommending it, but a lot of times the adjusters are just like, hey, no, we want you to at least go and fight this.
Wow. That's wild. All right. Let me change gears for a second. So, doctors, when attorneys are sending you an injured worker, what should they tell the injured worker before they go and see the doctor, before they go see a QME specialist?
I would like it if they, first of all, tell the truth, 100% tell the truth, no coaching. But they really need to tell them to really think about their symptoms. I had a patient leave that forgot that she had meningitis and was hospitalized for 6 months. This was an SIBTF case, but she was ICU hospital 6 months. It wasn't in the medical records I got. And she called me. With SIF, you could do ex parte. So she called me. She's like, a week later, she's like, have you written the report? I'm like, no. She's like, I was in the hospital for 6 months. I have brain damage long term. Like, so they were not trained to think about every single thing that they had. So if they just go through line by line, what's this body? And a lot of guys are so stoic, and some ethnicities other than others, or just come in. I've had a guy who fractured his scapula, broke his zygomatic arch, had a brain injury, had a splenectomy, was in the ICU, and he comes in, it's 5, 6 months later, and he's like, don't put me off work. I'm doing great. And I'm trying to just do range of motion, and he's sweating and he's almost crying. He's like, no, 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 I'm good. Send me back to work. You don't want that. He's just, he has a family and he's worried about the consequences. Explain the consequences aren't going to be as dire as they think. Things like that. Get the whole story for them to give to us and not leave anything out. I think that's the best thing I can say.
And at the point where they're going to see you, have they already seen other doctors from the defense side often?
So usually they first go see all the defense guys, right? So they see a lot of defense, Concentra, U.S. Health Work stuff, and then they go end up at Synapse or with Dr. Rubenenko or Dr. Dorsey. So yeah, I see all that by the time they get to me.
So do the attorneys have to explain that this doctor's not like those doctors?
Yeah, exactly.
They're not just going to say, hey, go back to work.
Right. Right. And a lot of these poor guys get bills, like they have to go to the emergency room 2, 3 times and the insurance isn't paying the bill. And suddenly they're getting sent to collections for $20,000, $30,000, $40,000 bill. They just want it to be over. So if they can coach or not coach, but educate them as to the consequences aren't as dire and, the risks aren't as bad as they think that it'll be.
And then, how important is an advocacy letter and what should that include?
It's funny. I'm a little egotistical. When I get a form advocacy letter, I kind of get insulted because I'm putting all this time into it. And I get a form, okay, don't forget Kite and Escobedo, And then the ones that are really good, I get some really, really good ones. And it helps guide me as to the tone and where both parties are and body parts that are contentious and body parts that aren't. I'm a big, big, big fan of an advocacy letter. And I'm one of the few guys that reads them. And I actually answer the questions if they're real questions and not just form questions.
So don't send the form letter.
Not to me.
All right. And I think we covered a lot of this, but how else do you go about getting additional QME panels, and what steps are necessary to bring to the judge when this is needed? Is it pretty much just what we just went over with that case, or is there more to it?
And well, also, so for Judge Graff, I hope that you can answer this question because a lot of us are sometimes at a loss, especially, handling cases from board to board and everyone having different rules. Because I don't think there's a certain set of rules when it comes to this, right? Before some judges, they're like, did you file your petition for additional panels? They're like, no. Okay, you're going off calendar, right? Or I have some judges who at different boards are willing to issue a additional panel based on just a petition for additional panel. I file a petition and a DOR at the same time. Then I receive an order for an additional panel, and they also take my hearing off calendar, which is great. Then I have other judges who are just like, no, just file for the expedited and let's go forward. And so sometimes I'm at a loss, and I want to do the path of least resistance and not bog down the judge and use a lot of judicial resources. So hopefully, Judge Graff can give us shed some light.
You want me to tell you what do you have to do, or what are best practices? I can tell you this, which is that it's always best practice to file a petition. Sometimes you can get away without doing that, but it's a better idea to do it and set forth what is the basis for your claimed entitlement to an additional panel. And as you touched on, you can, under Labor Code 5502B3, file an expedited hearing on the issue of entitlement to a medical legal evaluation. So that is, in my opinion, a proper expedited hearing. Can you get an additional panel on that basis? And really, I mean, what you have to have is you have to have some evidence. And I said this at a panel that I was on at a convention last winter. It's the question is, the argument, I have to have evidence in order to prove that I need evidence, is really circular. And what the board has said over and over is, well, you just need something. There are cases where, on the basis of a bare allegation alone with nothing, that would not be sufficient to order an additional panel. But you've got really two paths to do it. You have to, at a minimum, make the allegation of injury, right? And then ideally, you've got some medical record somewhere which talks about somebody's making these complaints. But if you've got that, that's going to be enough. If you've got a QME in one specialty and you ask that doctor, are you capable of doing this, or do you defer to this other specialty? That's also going to be enough. I've told people I don't have a case on it, but if I had absolutely nothing and then the applicant came before me and wanted to testify, I'm having this problem and no doctor is willing to document it. And I've heard many times, I went to a doctor, I told them I had this, that, or the other problem, and they said to me, I cannot comment on those things because I've only been authorized to deal with these specific body parts, and so I can't deal with this. If I had somebody give me that evidence, on the basis of that testimony, I'd probably say you have to have a panel because, again, you need to have a competent opinion to provide a med legal foundation that I can make a decision. And the discovery process itself is not prejudicial. That's what we're here for. So if an applicant needs to be evaluated in a specialty for which they legitimately claim injury, then you're going to be usually entitled to a panel. I hope that helps.
Yeah, it definitely does. But just for practical matters, when we file our petitions, and sometimes there's no action being taken by the board. So, again, we don't want to waste judicial resources. So we're like, hey, I'd rather file my petition than file for an expedited. So is there anything, can we call into the board and ask that petition be active on, or do we just have to file a DOR?
I can't speak to that. I can only speak for my own practice versus other judges. I mean, if you file a petition, that's going to generate a task. So here's a peek behind the curtain. So when you file documents in EAMS, they will generate tasks. And depending on what you label that document that you file, it will generate different types of tasks. There is a label that you can put on a document, which is petition for order for additional QME panel. If you file a document with that label, it will generate that task for your judge, who is the case owner in Eames. So I can go into my task bucket and I can see somebody has specifically filed for this kind of an order, and I can take a look at it. You can always call the call center to see if you can get action on one of these things, but some judges will decide for whatever reason they don't want to issue an order without having a hearing. So it's always going to be best practice to file a DOR, or to file a DOR for expedited hearing, and certainly to file your petition for the additional panel laying out your evidence, because the more that you can give to the judge, the more likely you will get an order without having to go further. But I mean, everybody's entitled to their due process, so it really depends on the case.
And those are your best practices, not necessarily everybody's.
Well, yes.
Yeah.
But I think most people would agree, the more that you give the judge,
Absolutely,
more likely you will get what you want. If you just file an expedited hearing without a petition, I mean, you know, then you run the risk of a judge saying, well, you haven't done steps A, B, C before you went to D. Or if you file a petition and just say the applicant's entitled to an additional panel because this doctor said so, but then you don't attach a copy of the order or the medical report. I mean, that sounds ridiculous, but I've seen that. And it's, well, I can't go based off of your representation. You want to put something in that lets me see that that's what that doctor said? Okay, then maybe. I mean, these are the things that you should do if you want to get what you're asking for.
Can I bring up a quick point regarding that, Judge Graff?
Sure.
You were mentioning how so many patients come up to you and they say, look, I've been complaining about this for 6 months and the doctor just doesn't want to hear it. And what I would recommend to all the attorneys there, I see this on the other end of it, the medical end. In terms of the evidence, don't just look at the doctor's reports, but many doctors, including myself and many therapists, acupuncturists, and chiros, they have the patient fill out a form when the patient's there in their own writing. And they have that human body where the patient draws circles where their body hurts. And I'll tell you, so many times, I would say the majority of times, the patient has circled all these body parts that they're telling you the doctor didn't want to listen to. And it's in the evidence. It's in the therapy notes. It's in the acupuncture. It's in the chiro notes. It's in my notes. If you just get the original paperwork and you look at what the patient was complaining about in their own writing, and that'll make your life a lot easier.
Yeah, it sounds like it. All right. I've got a few questions here that I'm going to go through quick. So first question is for Robert. Do you find your clients getting better PD outcomes or treatment outcomes on a pain management panel versus the traditional ortho and neuro combo?
That's an easy answer. The answer is yes. And, you know, I encourage, you know, I think hopefully this is more of the trend amongst the applicant attorneys. And, you know, it is a little bit, I know that the trend was always like, go to Cairo, go to Cairo. But, you know, it's a lot harder for the defense attorneys to fight us when we have a medical doctor giving an opinion. So the answer is yes.
Makes sense. Next question. Do you agree rheumatology is premier specialty for fibromyalgia? Question, post-kite vigil Havanis, do you agree an FCE must be done to address actual impairments of ADLs, and then comment accurately on adding or combining impairment? Why are there only 2 OBGYN QMEs in California is the last part of that.
Industrial.
I don't know if anybody can answer the last part. Anybody want to take any of that?
I think I might need that broken down again. I mean, I can't address the question of why there are only 2 OBGYN and QMEs, but
I like that one. All right. Do you agree rheumatology is premier specialty for fibromyalgia?
I've seen rheumatologists address those complaints with authority, is probably the best way that I can answer that. I've seen reports from rheumatologists where they say, here's the disease process and here's why I believe it's industrial. I can't say they're better than others at dealing with it, but I can say that in my own experience, from reviewing reports that have been submitted to me, those specialists have done the best job at explaining it in a way that makes sense. Because again, something that people often forget is, let's zoom back and think about what we're doing here. This is expert testimony. It happens to be medical reporting. Your doctors are providing you expert testimony in a case. And really what that is you're using an expert to provide in language that is understandable to a non-expert why this is true or this is not true. And so the better job that anybody does in explaining those things, the more useful their reporting is. And so if you can connect the dots, that's okay. That's what you're looking for in any situation, is somebody who can take you from point A to E with a long continuous line. So that hopefully helps on that point. I don't know.
All right, and let me go ahead and ask the next one. Post-kite vigil Havanis, do you agree an FCE must be done to address actual impairments of ADLs and then comment accurately on adding or combining impairments?
I don't even know what that third case is. Is anybody else familiar with that case?
No.
Havanis? I don't either.
But post-vigil, it looks like that's a big game changer. I mean, huge game changers for these evaluations and what ultimate disability will be.
I haven't. I'm sorry, go ahead.
No, Judge Graff, there's a good question there that says, if you have a signed claim form by the applicant that lists complaints that have not been addressed by a doctor or a QME, is that enough in lieu of testimony for an additional panel?
Could be. I mean, I don't know. If somebody in their own hands, so I mean, you know, again, I see all manner of claim forms. I see claim forms that are clearly completed by applicant's attorney upon retention. And then I see ones that were clearly done by the injured worker, which were turned into their human resources department, and then they got an attorney. If I see one that the injured worker did, and it's right after an injury, that's going to be pretty convincing to me that somebody is making an allegation and that's what they're alleging themselves, and it hasn't been directed by somebody else. Probably would work.
That makes sense. So I got a FYI, if applicants are getting billed for work comp treatment and it goes to collections, a case can be filed in federal court against the doctor or hospital. Are aware that it's a work comp injury. Most have been told they continue to bill and send it to collections. So that was just an FYI from someone.
Just real quick, I was at the CAW in Long Beach, the subchapter meeting last week, and they had an attorney speaking there. And he sues the heck out of the insurance companies, and he has like a 99% success rate. So if you guys want to talk to that chapter, that attorney gave a very good lecture on protecting your clients.
Yeah, I think I had the same attorney on a webinar probably about a year ago for the same thing, and he does an amazing job. All right, so what injuries would be beyond the abilities of a chiropractic QME? Who wants to try to speak to that? Doctor?
You sure you want me to say that? Most?
Yeah, I figure I'll give you that one as a softball.
Well, I don't know. It's just, you know, chiro's chiro, so they can't do the internal medicine portion. They can't do the rheumatological portion, neurological portion. If you're going to do, you know, I never really understood the whole chiro thing. This QME world, it was very surprising to me how much chiros are used. I would really focus my energies on getting a good, fair, honest orthopedic. And there are some really amazing chiros. I don't want to put them all in the same boat. I know 3 chiros that write better reports than me that are absolutely amazing. But as just a general thing, the training, I don't feel is as much there as the orthos or the pain or the rheum or the PM&R. So that's just my 2 cents.
And then what type of injury would be appropriate for an acupuncturist to be a QME? That's an interesting one. I don't know how you answer that one.
I have never in my entire career seen an acupuncture QME's report. I don't know if anybody, I'm sure somebody's gotten one, but I've never seen one. So I don't even know what it would look like.
There we go. All right. Some of the questions are pretty interesting. All right. I subbed in a case where the parties attended a PQME and gave final findings. The PQME diagnosed the IW injured worker outside the specialty. The case was at trial and there was no request done prior to the MSC from the prior parties. I filed a petition for additional panels during the proceedings and the trial judge denied the additional panel. Since the parties agreed to use AME, PQME, my question is, did the judge have authority to rule and deny the request at the time of trial? Testimony was not taken due to the stipulation.
That's a difficult question to answer because I think it really depends more on the facts of that case. And all of that is going to be based on a removal standard because it would be a discovery order. I think it's your better bet in getting that reversed potentially, if that's what you're trying to do, is post F&A or F&O. I really couldn't answer that without having more information.
Yeah, one of my favorite attorneys, Mad Dog Brett Bora, just chimed in and said there is an acupuncturist panel, but they are not allowed to comment on PD. So what's the point of using an acupuncturist? It's a perfect Brett Bora comment. So, all right. Another question. Do you agree DC gives more thoughtful interviews, spends more time with applicants, and thoroughly recommends a wide range of additional QMEs based on interviews and records?
I can't really comment on that, having used a Chiro QME in a long time. So I'm not sure.
I would think it depends on the Chiro QME, and it also depends on the doctor that they're going to see is how much time they're going to spend. Doctor, would you agree with that?
Like I said, I know there's 3 chiros I know. Not only are they amazing QMEs and they do spend a lot of time, but they're also amazing clinicians, you know, hands-on type of, I send all my patients to them. So it is specific to the person, like you said. That's the problem with the QME process. It gets to be so random, you know, you just don't know. I wish it was just all AMEs and you can really pick good people and move on with your life, but.
Yeah, I got you. I got somebody that wants you to name those 3 chiros, so that's
Well, my favorite right now is Dr. Donna Clowen. She's an amazing clinical treater and she does great QME, spends hours in the room. I mean, like the patients want to walk out and she doesn't let them walk out, that type of QME.
That's pretty cool. All right. Somebody really doesn't like those Fresno orthos. They said, what can be done about the Fresno orthos? They are hurting the injured worker. So I don't know what can be done about Fresno orthos.
Let me make a general comment about that.
Great.
If you think that the judges don't know what the proclivities are of certain doctors, you are mistaken. If you come to the judge with a report from a doctor that is a washout report, and it is a known washout artist of a doctor or practice, that report is almost certainly going in the garbage. So I would be careful about relying on a report that you know, although, I'm speaking primarily to the defense bar. If you know that the report is very favorable to your client, but very obviously nonsense, a judge is not going to be inclined to follow it, no matter if that doctor was the QME. And there are doctors on the applicant side too. I'm thinking of one in particular who, no matter what, they're going to have 15 diagnoses. And the judges know that that's always what you're going to see. So make sure that if you're relying on a report, that the report is honest, because the judge will know if it is or if it isn't, or should.
That makes sense. All right. Another one, I've had petitions for additional panels denied when QME deferred to other specialty. Defendants object to additional panel and insist that the PTP request consult and need objection before trigger for need of a panel. Judge agrees. Judge Graff, is this judge wrong?
Judge Graff does not agree.
Graff does not agree.
I think that the case law has made it very clear that the standard is extremely permissive. If a doctor is going to punt and say, I defer to another specialty, then that's been explicitly made clear that that's enough.
Yeah, and just as a practicality matter, I'm always of the opinion, if we agree to a one-time consult in the MPN and this one-time consult is in your favor, you're going to object, and then we're going to end up at a PQME. If it's not in my favor, I'm for sure going to object and be requesting a PQME. So let's just save us all the trouble and the time, and let's just go straight to a PQME.
So Judge, how do you feel about sending an applicant to a QME who is known to be a washout type of evaluator with a short list of innocuous questions about the QME process and a tape recorder provided the applicant tells the doctor he is recording the evaluation?
Well, I think sending an applicant, I mean, this is really just sort of off the cuff. This is absolutely just my opinion.
Yeah.
Sending an applicant to a doctor who you know is going to be unfavorable to the applicant and doing that as a strategy, I think is just a bad idea, because you don't know ultimately how the report is going to come out. And anytime that you have a report that is authored by a doctor, if it's well written, there's a chance that a judge is going to follow it. So a judge may not agree with your assessment that the doctor is a washout artist. So I would not deliberately send or strike so that an applicant goes to a doctor who is known by reputation to be hostile to an injured worker. There is a case that makes it pretty clear that applicant has the right to record an evaluation with their phone. There was another case that originally said, yes, the applicant can have a court reporter, but I think there's a more recent case where the applicant wanted to record with their phone and the doctor didn't want to do it. I mean, the board has said that you can do that. And if a doctor refuses to go forward with an evaluation for that, and that came before me, then I think that would be cause to go forward with a different evaluator.
That makes sense. So Robert, you had sent me over a couple of cases that we included in the reference materials. Do you want to talk about either of those?
Yeah, one of them was the Lofton versus, which is cited in a Lexus case, basically saying that it race very for changing. So whoever's is generally going to control the specialty. So if at that time it's the applicant, with the notice of delay or notice of denial, then we should be fine. And then the second case, which was more recent, was the Porosalo case versus the state of California. I know for the longest time, it was always that the defendants, if they were going to object to the specialty, they had to bring it before the DWC medical unit and exhaust those remedies. But this case law now says you can bring that issue straight to the WCAB and bring it before a judge without going forward or without going through the DWC medical unit. Is that correct, Judge?
I wish I could answer that, because unfortunately you broke up quite a bit while you were explaining.
Oh no.
Yeah,
What
looks like your internet connection's a
explain-
little unstable.
Oh, okay. I'm sorry. Well, I was explaining that the Portello case is saying that we don't have to bring a specialty issue before the DWC medical unit anymore, that we can bring it directly before the WCAB and we can bypass the medical unit.
That's true. That is what that case says. So you are not, as of that case, required to file a challenge with the medical unit itself. You can take that directly to a WCJ. I mean, it's not binding authority, but it's a panel decision. But I think that's at this point pretty clear.
Okay.
Yeah, and your first case, you broke up through the whole thing, so I missed the.
Oh, okay. Oh, it was the Lofton versus the County of Sacramento, which is basically stating that it's whoever has the right to select the PQME at that time is going to hold the right to the specialty. And, as Judge Graff was saying earlier, that the standard for changing specialty is the threshold is very high. So it's basically first come, first serve.
Yeah. There's a question here. How do you get around the problem of missing the 20-day window to object to a PTP report for accepted case that has already been PNS by PTP to obtain a panel?
Let's see.
Those are two different labor code sections. 4062 is the one that has the 20-day limit. 4061, I think the standard is within a reasonable amount of time. So if you've got a dispute over PD, as long as it's within a reasonable amount of time, that 20-day limit doesn't apply. That's only the Labor Code 4062 disputes, which do not include PD.
Okay. And I got another question just came in. So the panel decision makes regulation 31.1B invalid. It currently reads, disputes regarding the appropriateness of the specialty designated shall be resolved pursuant to section 31.5A, subsection 10 of Title 8 of the California Code of Regulations. Either party may appeal the medical director's decision as to the appropriateness of the specialty to a workers' compensation administrative law judge.
I mean, my answer would say it doesn't invalidate it, but it definitely, the noteworthy panel decision allows for a alternative, and that alternative is to bring it before the WCAB.
Okay, and Judge Graff, is there any way to even the playing field when defendants use an out-of-state address, so applicant has to wait 5 additional days before requesting a panel, whereas defendants can request 5 days earlier?
Oh, that's interesting. I'm not sure that I'm going to accept as a matter of fact that if defendant is requesting the panel, that the system would let it go through and not give you an error message, versus that if applicant was doing it, it would tell you you have not yet had sufficient time in order for the system to give you a panel. I don't know that that's in fact the case, but I'm going to assume for the purpose of your question that it is. That's really interesting. And I think if I had that come in front of me, then what I would want to see, if applicant is making the argument, hey, I tried to get this panel on this date in this specialty, and I should have been able to, but the only reason why I couldn't was because this defendant has an out-of-state PO box and the system would not let me put it through. And here's my proof, because here's a screenshot or a print of the thing saying it's too early. Here's my form data as to what I would have requested, and I can prove theirs came later and I should have been able to do it. If I had that, I'd probably say, yeah, I don't think that's fair. But, you know, I really don't know what else you can do other than document everything that you've done.
Yeah, the online QME request system counts days off of the requester's address. So AA in California has to wait longer than DA who requests with an out-of-state address.
I think that's not fair, but
it doesn't sound fair.
That's an anomaly in the coding.
All right, I got one more question here, and it's for Dr. Coppelson. And then I'm going to go ahead and close this out for quick. Dr. Coppelson, somebody asked, what do you think about UCLA's football future in the Big Ten?
I'm too busy reading Honorable Judge Rasp's book. I don't know.
There you go. All right. So first of all, I want to thank all of the panelists for coming on. I know you all are very busy, and sharing this time to answer questions and to go over this is I know very much appreciated by the whole WorkComp community. So I want to say thank you. Also, we will be sending out an email with the information on getting your CLE, and also a separate one with the recording, and where you can find the recording of this webinar and the contact information for Dr. Coppelson and also Robert Herrera. So thank you very much, panelists. I appreciate your time. You did a great job, and hopefully I'll talk to you soon.
And John, thank you for to Gemini and you and Anthony Viramontes, everything that you guys do for our community. So thank you.
I appreciate it. Thanks, guys.
Thank you.
All right. Have a great rest of your week.